Hello, people. Welcome to Content Cut Short. We are here to deal with a topic of Evidence Act, motive, preparation, and conduct, which is given under Section 8 of Indian Evidence Act. As we all know, when a crime is done, there is always a motive behind it, and always preparation done to commit such crime. And there is also conduct, action taken to commit such crime. Without action, there is no crime. So these all three things are important, and these all three things are relevant in a criminal trial. So let's start with the topic. Starting with the introduction, Section 5 to Section 55 of Indian Evidence Act deals with the relevancy of fact. It states in what condition a fact can be relevant to fact in issue. One of such condition is given under Section 8 of Indian Evidence Act. So as we all know, Section 5 to Section 55 of Indian Evidence Act deals with the fact which can be called to be a relevant fact. It deals with various circumstances in which a fact can be said to be relevant in a criminal trial. One of such circumstances, one of such condition is given under Section 8, that is motive, preparation, and conduct. As per Section 8, any fact is relevant which shows or constitute a motive or preparation or conduct for any fact in issue or relevant fact. It is important to ascertain these facts because these facts may help both the prosecution and the court to infer the mens rea or guilty mind and provide a link in establishing the commission of the offense. So here, as per Section 8, it deals with the motive, preparation, and conduct. And why relevancy of motive, preparation, and conduct is important? Because it states the mental element, it states the mens rea, the guilty mind, the intention behind doing an act, and the way by which a act is done. So these all elements are really important. That's why they are relevant, and the prosecution can bring it whenever he wants. He can bring such motive, preparation, or conduct of the accused or his related persons before the court, and this can be said to be relevant, and this may be proved. So, talking about Section 8 of Indian Evidence Act, according to Section 8 of Indian Evidence Act 1872, the following facts are construed as relevant facts. So, when this motive, conduct, or preparation can be said to be relevant, there are two conditions. Firstly, if there is some fact which constitute either motive or preparation. So if any motive or preparation is towards a crime is revealed, then such motive or preparation may be relevant. Secondly, any fact that constitute or shows conduct. So any conduct related to the crime, related to a criminal act is relevant. Conduct herein includes conduct of any party, the party's agent, and the victim. However, for conduct to be considered relevant, such conduct must either influence or be influenced by any relevant fact or fact in issue. So any conduct, in order to be relevant, it must be related to fact in issue or relevant fact. So it must be by any way related to the facts of the case, the fact in issue of the case. Let's look into a illustration. A is accused of a crime. The fact that after commission of the alleged crime, he absconded or was in possession of a property or the proceed of property acquired by the crime or attempted to conceal things is which were or might have been used in committing is relevant. So in a crime, if a person has absconded and he was found with the possession of something, some knife or some dangerous weapon, then in that case, it can be said to be a relevant conduct. Now, talking about the conduct of a person is relevant if it is related to fact in issue or relevant fact of suit under proceeding in court. So, if a suit is running, if a proceeding is running in court and any act or conduct is found that is relevant to the fact in issue or relevant facts of the suit, then that conduct would be relevant. And conduct of any person an offence against whom is the subject of any proceeding is relevant if such conduct influences or is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent conduct. So any conduct which is influenced by the fact of the case or influences the fact of the case, then such conduct would be relevant, and that conduct may be previous or subsequent. It may be after the commission of crime, or it may be just prior to the commission of the crime. So there are two explanations in conduct under section 8. Explanation 1 says a statement is not a conduct. So a statement can never be a conduct, because in conduct there must be some act done. It is not that a person speaks something or tells something or reveals some fact. It cannot be relevant under the section 8. Under section 8 there must be a conduct. As per explanation 2, when the conduct of any person is relevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. So any conduct of any person is, if it is relevant, then any statement made to him by any third person would become relevant. When we talk about illustration, a alleged person of crime destroys evidence. So if a person destroys any evidence, that can be an example of conduct, and he can be held liable, because destroying of evidence may lead to injustice. Now look into some essentials of a valid conduct. So the conduct must be of a party or any agent of such party or any accused person. The conduct must be in reference to a suit which is in proceeding, or any fact in issue or relevant fact. A conduct must be influenced by fact in issue or must influence a fact in issue. So talking about motive, motive generally means that which moves or induces a person to act in a certain way. So motive is a mental element. It just enables or forces a person to commit an act, to do a conduct. So it may be desire, reason, or it can be fear or revenge. So it can be anything. Any mental element which enable a person to commit an act, to do an act, is said to be motive. Motive is productive of physical or mechanical motion. Motive is often used as meaning, purpose, something objective and external, is contrast with a mere mental state. So it is a mental state. It is a purpose or an objective for which an act is done. So motive in itself is no crime, however heinous it be. But once the crime is committed, the evidence of motive becomes important. So without conduct, without crime being done, motive is not, it cannot convict a person, it cannot make a person liable. So motive merely cannot make a person liable, there must be a crime done. Now let's see an illustration. X killed Y, and after some time brother of Y killed X. Here motive of Y's brother in killing X was to take revenge. So here the revenge is the motive. Now let us talk about preparation. This is the last topic here, preparation. So let's do it. Acts of preparation are relevant under this section. Again, preparation by itself is no crime. So preparation, like motive, is no crime. There must be an act done. So preparation, as the name suggests, is just the readiness or preparation done to commit a crime. But once an offense is committed, the evidence of preparation becomes important. So once an offense is done, once an offense is committed, now the preparation, the evidence of preparation becomes really important. For example, in R versus Palmer, where the death is caused by poisoning, the fact shortly before the accused procured the poison similar to the one administered is relevant. So the poison which was found in the person's dead body was procured by a person just 2 days before his death. So that was a relevant thing, that was a relevant preparation, and that was tried before the court. So let's look into an illustration. A was found buying a sharp knife before 2 days of a murder which was committed with a similar knife. So this may be termed to be a valid preparation and may be relevant.